Kim Seelinger, thank you very much for being here with the Wayamo Foundation in Pretoria, South Africa, for all of your work here and at the International Criminal Court and in academia. I want to start by asking you about the 2023 policy report on gender-based crimes that you worked on and what major changes it entails from the prior report of 2014.
So one of the main sort of evolutions with the 2023 policy on gender-based crimes as compared to the 2014 policy on sexual and gender-based crimes is indicated in the titles of the two policies, actually. So the original policy had focused on sexual and gender-based crimes as such, SGBC, which people still refer to quite a bit, and that's completely understandable. And that inclusion of the S for sexual at the time really flowed out of decades of really feminist lawyers and scholars realizing that the sexual nature of some of the violence that happens in armed conflict, for example, was being ignored or wasn't being seen as something important, as a critical feature of an armed conflict, for example. And so bringing more attention to it was really quite important. And that's been successful, I think, over the years, in the last 15, 20 years. In 2023, when we revised the Office of the Prosecutor's policy, we had a lot of discussion with experts, our own colleagues internally in the office, but also externally, about how, in a way, it might make more sense to reframe things conceptually a bit. And so we opted for a policy on gender-based crimes, not dropping the S, but placing it in a different way. So when we talk about gender-based violence and crimes involving gender-based violence, we're talking about crimes involving sexual violence, reproductive violence, and then other forms of gender-based violence that may be neither sexual nor have sort of reproductive harm involved. And then there are forms of gender-based crimes that are neither sexual nor reproductive, as I said. And you could look at the most recent application for a warrant of arrest in the case of Afghanistan, which, among other things, includes the denial of education for girls. Right? So we wanted in this policy to sort of revisit and clarify the relationship among different types of harm, all of which are gendered in some way, but are not coterminous, right? So that was one of the major, I think, shifts in the policy, just to expand our thinking and clarify our understanding of relationships of harm.
Can you also tell us a little bit about the importance of mainstreaming a gender focus and a focus on gender-based crimes in the work of the Office of the Prosecutor more generally?
I was able to spend some time in the office as staff recently, which was incredibly eye-opening, very humbling, and quite rewarding. And I think, there are many colleagues, both in the office and outside in national systems that I've worked with, who, weren't quite sure why we were paying so much attention. Why do we need a policy on gender-based crimes, for example? And I think, ideally, we wouldn't need one. Right? Ideally, gender-based crimes would be considered and given the same weight, the same consideration, the same attention, the same resourcing for development as any other crime, as murder, as pillage. And I think most people see conceptually that should be the case. But what ends up happening, of course, is that historically it's not often articulated when it was very much present in the conflict or perhaps present in the evidence in front of us. And so the idea of mainstreaming, it's about building the muscle, and until something is absorbed fully into the body of an institution and becomes eventually part of its DNA in a way, right? Can we mainstream these ideas into every step of our work, every body in the office? So I'm not just talking about raising awareness and strengthening the capacity of our investigators to think about these things, but also our analysts, who are not necessarily trained in gender analysis, but can they start developing ways of detecting and organizing the huge volumes of information we have so that we know, okay, when we're looking at these crimes, do we know how they may affect women or men differently? Are we disaggregating for gender at all? Are we disaggregating for gender overlapping with ethnicity? Can we actually see these patterns? And this has to be mainstreamed, otherwise it often doesn't happen. I'm thinking also about our interpreters. The interpreters we use, they're critical to our work. If you have a court that sits one place but is, concerned with crimes committed elsewhere, we're often working in different languages. And colleagues like our interpreters are critical, to have them also understand what we're looking for, to have an awareness about how gender may figure into a conflict, how a harm that may not look like it's gendered may actually have gendered impacts, and what terminology they would use, right? What do they understand about gender norms in the context? What is the right language to use? So I think it's critical because at every step of our process and for every person who has a shoulder to the wheel in this work, being aware of how gender figures into these situations is going to be critical for whatever role you have. And until we mainstream that fully, any little gap is going to have downstream effects on the evidence we're able to collect, right? And the quality of that evidence, and ultimately who's going to have access to justice and potentially reparations.
We've seen in some cases, like the Ongwen case, that gender-based crimes were only added many years after the investigation was initiated. But could you tell us how important it is to have a focus on gender-based crimes at the very initiation of investigations?
When, at least in the ICC process, and this is different in certain national processes, but at the preliminary investigation stage where we're absorbing a lot of information, right? And you're trying to there's a lot of sense making that happens then. If we have a gender lens at that point, then we can start seeing initial patterns, at least initial indications of gender-based crimes, right? And that then gets moved and feeds into and informs what might become later a case hypothesis or an investigation strategy. And we again have to have a gender approach there to be thinking about, okay, well, who are we even talking to here? Who might have information about how gender is working in this society, even before the conflict, say? And that has to be built in, not just in the preliminary examination stage, but when we start thinking about what happened and why it might have happened to whom. And gender is almost always there, perhaps layered on with ethnicity or imputed political opinion or race or other features of a community or a conflict, right? But if it's not included at that stage, as the process winnows, we go from mass amounts of information to refining and refining and refining. And if it's not in the beginning, then it won't be included in the investigation strategy. There won't be space made on investigative missions. We will not have scanned for all of the possible people who could have filled us in on mass rape or the sale of women and girls or the way men were separated out and killed in an instance. So if it's not included in the beginning, we have less and less to work with. And eventually, when it comes to charging time, you can only charge based on the evidence you have, right? At that point. And so if it's not in the evidence you're considering, it also won't make it into the charges, in which case it won't make it into the courtroom, won't make it into a reparations order in case of conviction. So it's just a cascading dynamic, I think, that if we don't look for gender and other intersecting vulnerabilities perhaps early on, we lose the chance to capture it later. There's always the possibility, right? You can try to amend your charges, you can try to add things later, but that's not always a given. And by the time you have invested so much time and resources into an investigation plan and a series of missions, it can be quite challenging to then open up another line of inquiry just to attend to gender that you should have considered in the first place. Right?
Our focus has been so far on the International Criminal Court and tribunals, but do you think national authorities, including through the use of universal jurisdiction, can also do meaningful work when it comes to addressing gender-based violence and gender-based crimes? Or is this really something that is somehow relegated to international tribunals?
Definitely not. And we have already seen national courts make tremendous progress in investigating and prosecuting gender-based crimes under international criminal law. I mean, in a way, we're back where we started in that what you can do to investigate murder and pillage, you can do to investigate gender-based crimes. If the national system is able to do A and B, they can also do C, of course. It shouldn't be any different for international criminal justice. But I think it's really helpful to look at what national systems have already done for the prosecution of gender-based crimes using international criminal law. People have, I think, really lauded the Sepruzarco decision out of Guatemala's high-risk court, where over 30 years after the civil conflict there, Indigenous women, secured a victory in court for the domestic servitude, the sexual slavery they were subjected to decades ago as crimes against humanity. We see the cases even in the military tribunals in Eastern DRC that are often featuring sexual violence and securing convictions. And then in Uganda, in the National Crimes Division, of course, we had a conviction for Thomas Koyalo's commission of crimes including rape and sexual slavery during the conflict in northern Uganda. And these were not universal jurisdiction cases, but they were done, of course, within the national system using international criminal law. But there's, of course, the potential of doing this in universal jurisdiction. It shouldn't matter, actually. The trial of Hissène Habré, the former president of Chad, in the courts of Senegal, as the Extraordinary African Chambers, was quite impressive in many ways, in that it was a trial of a former head of state, including for gender-based crimes committed not only by his subordinates, but there were charges brought about his personal perpetration of rape against a former prisoner. Now, that's a complicated case, and he was acquitted of his own personal perpetration of that one woman, violence against her. But it is to say that these cases can absolutely proceed in national systems and through universal jurisdiction. I think it will depend on the state and its access to territory, whether there are witnesses present or accessible, potentially as a part of a refugee or diaspora community, what kind of cooperation exists between states for evidence gathering. But you can do these cases at distance, of course. And I think this is incredibly exciting to see this new phase of work in the national systems.
I'm going to put you on the spot a little bit. So I'm going to give you a magic wand, and I'm curious, if you had that magic wand, what is one thing that you would do or change to promote justice for gender-based crimes?
I need a couple magic wands, Mark. Why do I just get one? But the one where I think we've fallen really short, I mean, we have a lot of challenges, a lot of things we need to do better, at every level. But where I think we've really fallen short is in our ability to actually deliver reparations in these cases, right? We have multiple cases in DRC, in the Habré case. We have challenges at the ICC, but where victims and survivors of all crimes, including gender-based crimes, become entitled to reparations, I mean, I can count on less than half my hand, maybe even less than that, how many of them actually get the reparations they are sort of declared to receive, right? It's really, and I worry about it for a number of reasons. Partly reparations are important in and of themselves, but we lose the trust of survivor communities when we're asking them to engage in a legal process. And what motivates many people, not all, is the idea that maybe, in addition to some conviction and some justice and seeing their perpetrators, taken to task, people need medical care. They want that school built. They want psychosocial support. They want things to repair the community rifts that have happened. And we more often than not, even if it's ordered eventually, they don't get it. And they wait years, and we lose whatever goodwill and faith and trust in the international justice project and systems that we had. And I think there's a bit of a moral and an ethical responsibility that we have to deliver more when we talk about reparations. Otherwise, I think it really brings into question justice for whom, actually. Like, who are we doing these cases for, if not for the survivors who get reparation at the end of the day? So that's what I would do with that magic wand, Mark. So you can hand it over anytime.